I should like Snuggies instead as a comfort blanket. Instead, I like Lorraine Schwartz, which is a problem.
Rings.
What? Sorry, we're not serious today. For me, wardrobe is always the way that I enter a character. I'm a very shy person. So if I look a certain way, then I can escape into that. Like in stuff today, I don't dress like this in real life, but like I'm having to like do interviews and talk. So I'm going to wear like a crazy pattern. Really crazy rings also are like my comfort blanket. It's just a very expensive comfort.
Besties, it's Katie Joy, and welcome back to the channel. I know it has been a little while since we took a deep dive into the ongoing legal saga involving Blake Lively, but we are still very much in the thick of the discovery phase. For those of you following along, discovery is often where the most intense legal maneuvering happens, and this week was no exception. In fact, things got a bit overwhelming because the filings were coming in fast and furious. We saw a response to a motion for sanctions, an opposition to Jed Wallace's motion to dismiss, and a motion to compel directed at Jed Wallace, followed by a supplemental filing. While some of this is standard, run-of-the-mill litigation, the sheer volume makes it clear that both sides are digging in their heels. I started realizing that not every single filing needs a dedicated video, especially since some of you get frustrated when rulings don't immediately go a certain way. However, there were a few critical developments this week that were not particularly favorable for Blake, and we need to break down exactly why they matter. One of the major issues involved Blake seeking discovery from Wayfair through an omnibus motion to compel. Wayfair's response was essentially to point out that the motion was premature and largely unnecessary. They argued that most of the documents Blake was demanding were already scheduled to be sent over, making much of her motion moot. Things got even more complicated when Blake sent a supplemental list of documents she wanted, extending the request all the way to the present date. This is nearly 9 months after the initial lawsuit was filed. Wayfair pushed back hard on this, stating they weren't comfortable handing over information that far past the original scope of the complaint. They argued that if the discovery window was going to be extended for her, it should be extended for them as well, though they didn't provide a very strong argument for why Blake should have to send more. The judge eventually stepped in and handed Wayfair a strategic victory. In the order regarding the omnibus motion to compel, the judge essentially told Blake that her filing was premature because Wayfair was already in the process of complying. He set a firm deadline for those documents to be handed over, but then moved to the much more important question, the scope of time. Blake wanted access to Wayfair's records up to the current day, but the judge disagreed. He ruled that anything happening now is far too removed from the core allegations of her initial complaint. The judge made a very interesting point. He noted that what Wayfair is doing today isn't part of a smear campaign, but rather a standard legal defense in active litigation. This is a massive win for the defense because it puts a firm end date on what the court considers the alleged smear campaign. The judge set that cutoff at February 18th, the date Lively filed her amended complaint. He explained that while some extension was justified, relevance diminishes the further you get from the underlying allegations. Simply put, the court isn't going to allow perpetual discovery. The judge specifically mentioned that Lively's claims of an ongoing smear campaign likely overlap with the defendant's right to advocate for themselves and defend their case in the public eye. By setting this February 18th deadline, the judge is essentially telling Blake that after that date, any public comments or defense strategies used by Brian Friedman or Wayfair are considered legitimate legal advocacy and not actionable harassment or a smear campaign. This ruling has huge implications. For example, the judge ordered that any communications or documents post-dating the complaint must be listed on a privilege log. This means that if Wayfair or their attorneys are communicating about the case now, Blake doesn't get to see those messages because they are protected by attorney-client privilege. Furthermore, when it came to Blake's demands for HR records and other complaints against Wayfair, the judge narrowed the scope significantly. She can only see complaints specifically involving sexual harassment or discrimination if they were filed against Wayfair, Jamie Heath, or Justin Baldoni. If there were other types of HR complaints, like the one we heard about regarding racial discrimination that was previously dismissed, Blake has no right to see them. This keeps the case focused on her specific allegations rather than allowing a fishing expedition into every internal issue Wayfair has ever had. This boundary the judge has set is crucial for content creators too. If the judge doesn't view Wayfair's current defense as a smear campaign, it makes it much harder for Blake to go after YouTubers or influencers who are simply discussing the federal court case as it exists today. If we are forming opinions based on public filings in August, how can that be part of a smear campaign that allegedly started a year ago? The judge is effectively putting Blake on a leash, signaling that he will not entertain the idea that every piece of negative press is a coordinated attack. This brings us to the situation with Perez Perez Hilton and Megyn Kelly, who have both found themselves in Blake's crosshairs recently. Moving forward, the second major issue we need to discuss involves Mr. Perez Hilton. Now, from what I've gathered, Perez was physically in court yesterday in Nevada. My subscribers and followers over on Instagram were messaging me saying that Perez looked visibly upset and somewhat defeated while leaving the courthouse. The hearing in Nevada was deferred, and while the full details of that specific session are still emerging, the situation in the New York court took a very different turn. Judge Lyman, who is presiding over the New York case, did not buy Blake Lively's legal argument regarding Perez. Blake's team tried to claim that Perez had effectively waived his right to contest personal jurisdiction. Their logic was that because Perez had filed motions regarding the subpoena, specifically seeking a protective order to keep his information private, he was voluntarily participating in the New York legal system. This is a common tactic used to trap out-of-state defendants, similar to the arguments Blake's team is trying to use against Jed Wallace. However, the judge rightfully ordered that he holds no legal jurisdiction over Perez Hilton. Judge Lyman opined that a person can ask a court to protect their personal identity or seal sensitive information without accidentally giving up their due process rights. Essentially, just because Perez asked the court not to leak his private data doesn't mean he agreed to be sued or compelled in New York. This is a solid victory for Perez, as the judge ruled that Blake's motion to compel is denied without prejudice. This means the issue is dead in the New York court. If Blake wants those documents, she has to fight for them in Nevada, where Perez actually resides. This brings us to a larger pattern. Perez is just one of several large-scale content creators being targeted by Blake in what looks like a broad sweeping net. Just yesterday, Megyn Kelly notified her massive audience that she had also become a target. Blake's legal team made an effort to gain access to Megyn Kelly's confidential contacts, podcast sources, and internal communications across YouTube and other platforms. Despite these efforts, Megyn stood her ground and Blake walked away with absolutely nothing. Megyn Kelly had a very serious and professional response to these demands. First and foremost, she reminded everyone that she is an undisputed member of the press. We're talking about a woman who spent years at NBC and Fox News. She is a certified journalist, and the idea that she wouldn't be protected by reporter's privilege is legally ridiculous. Megyn noted that she came to her opinions on the Blake Lively situation entirely on her own. After reviewing the court documents, the evidence, and the various claims, she felt that Blake's story simply started falling apart. Megyn also clarified a point that many were speculating about, her relationship with Brian Friedman. While Friedman was her lawyer years ago, she stated that her opinion on this case has nothing to do with him, as he didn't even know Justin Baldoni at the time they worked together. It makes me wonder if other figures mentioned in the filings, like Billy Bush, have also been served with similar demands. What is so fascinating about this smear campaign allegation is that it is being dismantled piece by piece. If Blake is getting nothing from Megyn Kelly, and with the ongoing motions to quash from people like Andy Signor of Popcorn Planet and the uncertainty around Candace Owens, Perez Hilton was really the last curveball left for her. But since Judge Lyman ruled he lacks jurisdiction, the fight moves to Nevada. And you have to remember, Nevada has incredibly strong shield laws for reporters. Perez is happy with this outcome because it moves the battle to his home turf where the law is on his side. Finally, we have to look at Jed Wallace. Blake is still pushing against him, even though he already had one case dismissed for lack of jurisdiction. She is now asking the court that if they dismiss him again, they should sever him from the case and transfer the matter to Texas. It all feels a bit desperate and, frankly, like a form of legal harassment. She should have filed in the correct states to begin with, instead of trying to force everyone into a New York courtroom. Overall, while Blake had a few minor procedural wins this week, she suffered significant strategic losses. The most important takeaway is the boundary the judge has now established. By ruling that no smear campaign exists after February 18th, the judge has put Blake on a leash. She can no longer claim that every person on the internet talking about her today is part of some grand conspiracy. The court has decided that we are now in the phase of active litigation, and the public has every right to discuss a federal case. So, if Blake is getting nothing from Megyn Kelly, and the jurisdictional doors are slamming shut on Perez Hilton and Jed Wallace, we have to ask ourselves, what is left of this smear campaign theory? Megyn Kelly didn't just stop at denying the subpoena. She went on a 14-minute scorched earth tear on her show, calling the legal move an act of pure narcissism. Megyn's point was sharp. She argued that Blake simply cannot fathom that people might dislike her organically. In Blake's view, if a journalist or a content creator has a negative opinion of her, it must be because they were paid or manipulated by Justin Baldoni's team. Megyn's response was a wake-up call for the legal team. She basically said, "Newsflash, Blake. I came to these conclusions because of your own behavior. No man had anything to do with it." And because Megan fought that subpoena and won, she gave Blake absolutely nothing. This is a massive blow to the discovery process because it proves that the network Blake is trying to uncover might not actually exist. If high-profile journalists are forming these opinions based on facts rather than PR spin, the smear campaign argument starts to look like a house of cards. This brings us back to that crucial February 18th cutoff date set by Judge Lyman. By ruling that anything after that date is active litigation defense and not a smear campaign, the judge has effectively stopped Blake from blaming her current bad press on the defendants. This is a tactical leash. It means that if you or I or any other content creator talks about the case today, we are protected. We are discussing public records and a federal trial. The judge is essentially telling Lively that she cannot use the court to silence public opinion under the guise of discovery. And let's look at the victory some people are claiming for Blake regarding the Wayfair documents. Yes, the judge ordered Wayfair to hand over certain documents by a specific date, but he also noted that this was already going to happen. It wasn't a hard-fought win, it was a standard scheduling order. Meanwhile, the judge denied her access to the broader perpetual discovery she wanted. He recognized that, as time goes on, these documents become less about the original claims and more about the litigation itself, which is protected. The situation with Jed Wallace is another example of this boundary being drawn. Even if she tries to move that case to Texas, she's facing a defendant who has already filed a $7 million defamation suit against her. Wallace is claiming that her allegations of a digital army have caused massive reputational harm to his PR firm. By dragging him into this, Blake might have opened herself up to a countersuit that could cost her millions, especially if she can't prove he was actually part of a coordinated attack. As we move toward the trial date of May 18, 2026, the case is getting smaller and smaller, with 10 out of 13 claims already tossed out, including the most serious sexual harassment allegations. The focus is now strictly on contract law and retaliation. The circus atmosphere that Blake's team tried to create by subpoenaing every major content creator is being dismantled by a judge who values legal relevance over Hollywood drama. So, besties, the question remains, is this case treading water or is it sinking? When you lose your jurisdiction over the villains you've named in your story, and when veteran journalists are calling out your tactics as narcissistic, it's hard to see a clear path to victory. The judge has set the boundaries, the dates are firm, and the smear campaign has been officially put on a timeline. Tell me what you think in the comments. Do you think Blake can actually win a trial on just retaliation and breach of contract, or has the damage to her own reputation already been done? As of right now, we are officially on a collision course with the truth. Judge Louis Liman has cleared the calendar, and the trial is set for May 18, 2026. But here's the kicker. The case that goes to trial is only a shadow of what Blake initially filed. In a massive ruling this April, the court dismissed 10 out of 13 claims, including the explosive sexual harassment allegations against Justin Baldoni personally. This means Justin and all other individual defendants have been removed from the lawsuit. What remains are claims of retaliation and breach of contract against Wayfair Studios. This shift is a double-edged sword. On one hand, Blake's legal team, led by Sigrid McCauley, argues this isn't a loss. They claim the case was always about the devastating retaliation she faced for standing up for herself on set. But on the other hand, the dismissal of the harassment claims happened because the judge ruled Blake was an independent contractor, not an employee, which stripped her of many legal protections, while Blake is seeking nearly $500 million in damages, citing a massive collapse in her public sentiment, which reportedly fell from 81% to just 10%. The defense is firing back with a narrative of creative hijacking. They argue that Blake used the threat of these allegations to seize control of the film It Ends With Us. And then there are the deleted signal messages. This has become a huge point of contention. Blake's team claims there is an evidentiary gap because Justin's team allegedly used auto-delete on their communications. However, without those messages, it is incredibly hard to prove a coordinated smear campaign. The trial is also expected to feature a who's who of Hollywood. Rumors of a witness list including Taylor Swift, Ryan Reynolds, and Hugh Jackman have turned this into the most consequential legal proceeding of the year. But with the judge setting that February 18th cutoff we talked about, the jury won't be looking at what's happening on TikTok today. They will be looking at what happened in the boardroom and on set 2 years ago. As we head into these final 64 days, the pressure is on. Will a Manhattan jury see a coordinated operation to destroy a woman's career, or will they see a creative dispute that spiraled out of control? Either way, both actors are expected to take the stand, and for the first time, we will see the evidence that wasn't auto-deleted. Now, besties, we have to talk about the absolute bombshell that dropped just days ago. On April 20, 2026, Judge Louis Liman released a massive 152-page opinion that fundamentally broke Blake Lively's case. If you thought this was still a sexual harassment trial, I have news for you, it's not. The judge officially dismissed all 10 of the most sensational claims, including every single allegation of sexual harassment and defamation. But here's the part that is going to make your head spin. The reason why. The judge didn't necessarily say the events didn't happen. He ruled that because Blake Lively was technically an independent contractor and not a traditional employee, she isn't protected under certain federal and state harassment laws in the way she claimed. It's a cold, hard legal technicality that has effectively removed Justin Baldoni, Jamie Heath, and even Steve Sarowitz as individual defendants. They are out. They are no longer personally on the hook for this trial. Justin's legal team, led by Alexandra Shapiro, wasted no time celebrating the significant narrowing of the case. They released a statement saying they are very pleased the court saw through what they've called voluminous evidence and serious allegations that just didn't hold up under the law. So, what is left? The case is now a laser-focused battle over three things: retaliation, aiding and abetting retaliation, and breach of contract. And get this, the only defendants left standing are the corporate entities, Wayfarer Studios, the film's LLC, and the PR firm, the Agency Group. The judge's reasoning on the smear campaign is where it gets spicy for us as content creators. He wrote that while Wayfarer was entitled to hire crisis management specialists to protect their own reputations, certain conduct arguably crossed the line. This is the only reason the retaliation claim survived. The jury will now have to decide if hiring those PR firms was a legitimate defense or a calculated move to materially alter Blake's career prospects, and we can't forget the Stephanie Jones factor. While all this was happening, Justin's former publicist, Stephanie Jones, filed her own lawsuit alleging that she was caught in the crossfire of this PR war. She claimed she was forced to stop representing Justin because of threats that Blake would reveal misconduct if she didn't. This adds a whole new layer of he said, she said to the May 18th trial. With the sexual harassment claims gone, the hook of the case has shifted from a #MeToo story to a high-stakes corporate contract dispute. Blake is still fighting for that $500 million. But without the harassment claims to pull at the jury's heartstrings, she has to prove that Wayfarer's PR team actively tried to destroy her career, not just that people on the internet didn't like her. Now, if you thought the jurisdictional battles were intense, wait until you hear what was in the hundreds of pages of documents that were just unsealed. We finally have a look at the private text messages between Blake Lively and Justin Baldoni, and they reveal a production that was essentially a war zone. In one of the most shocking unsealed messages from May 2023, Justin Baldoni vents to a colleague that Blake was effectively holding the movie hostage. He wrote that she was threatening not to promote the film at all if she wasn't allowed to take over the final edit. Justin's exact words were, "She had the nuclear bomb. If she doesn't promote the movie, she can leak that I'm a bad person or that she felt unsafe with me. Then she's the victim." He even noted that the risk to his family's peace wasn't worth the creative integrity of the film. But Blake's messages tell a different story of emotional distress. She texted a friend during filming, saying she came home and cried because of the atmosphere on set. In a message to her co-star Jenny Slate, she referred to a general vibe from Justin that she wasn't into, ending with a firm, "Never again. Lesson learned." Then there is the Taylor Swift connection. The unsealed documents include texts between Blake and Taylor where Blake calls Justin the doofus director of My Movie and asks for Taylor's thoughts on a script rewrite. Taylor reportedly replied, "I'll do anything for you." Justin's team originally tried to subpoena Taylor, claiming she was used as leverage to force him into accepting Blake's version of the film, but that subpoena was eventually withdrawn after the court criticized it. What this unsealed evidence shows is that he said, she said on a massive scale. To Justin, this was a case of creative hijacking by a powerful star. To Blake, it was a fight for a safe workplace and protecting the story's integrity. With the May 18th trial date fast approaching, the jury is going to have to decide, was Blake a victim of a coordinated smear campaign, or was she a producer using her influence to seize control? The stakes couldn't be higher. Nearly $500 million is on the line, and both stars are expected to testify and face these messages in open court. As we approach the end of this journey and head toward that May 18th trial date, we have to look at the digital footprints that started this entire firestorm. One of the most fascinating pieces of evidence involves the metadata from the leaked stories that began appearing on gossip sites last summer. Blake's legal team is prepared to present forensic evidence that they claim tracks several negative blind items directly back to IP addresses associated with crisis management firms hired by Wayfarer. If they can prove that these firms were feeding stories to the press, stories that specifically painted Blake as a diva or a creative hijacker, then the retaliation claim becomes almost impossible to beat. On the other hand, the defense is ready with their own digital data. They've tracked the surge in pro-Justin sentiment on TikTok and Instagram, and they plan to show that this wasn't a paid bot army, but rather an organic reaction from fans who were simply comparing the two stars' press tours. This case has become a mirror for modern Hollywood. It's no longer just about what happens on a film set, it's about who controls the narrative on your phone screen. The judge's decision to limit the scope of the smear campaign to February 18th was a way to keep this trial from becoming a trial of the entire internet. But even with that boundary, the jury is going to be asked to decide where does zealous advocacy end and career destruction begin. Justin Baldoni has maintained a relatively quiet profile leading up to this, while Blake has been seen at high-profile events, surrounding herself with her squad of A-list supporters. These contrasts in PR strategies will undoubtedly be a subtext in the courtroom. Is Justin the quiet underdog, or is Blake the resilient survivor? Whatever the jury decides, the impact will be felt for decades. If Blake wins $500 million, every studio in town will be terrified to hire crisis PR. If she loses, it might send a chilling message to actors who want to speak up about their creative experiences. So, besties, this is where we stand. 7 parts, thousands of words, and one massive legal showdown. I'll be there in the courtroom, or at least refreshing the docket every 5 seconds to bring you the updates as they happen. Make sure you've got your notifications on, because when May 18th hits, the real drama begins. Tell me one last time in the comments, Team Blake or Team Justin? Or are you, like me, just Team Truth? Thanks for sticking with me through this deep dive. I'll see you in the next one. Bye, besties.